Hello friends, in today's session we are going to discuss the case of Shri P.V.Narasimha Rao versus State CBI SPS. Let us first understand this case in brief. In this case, the Supreme Court held that members of Parliament are considered public servants under Section 2C of the Prevention of Corruption Act 1988. It was also held that before initiating criminal proceedings against a member of Parliament, prior sanction must be obtained from the presiding officer of the respective house, the Speaker of the Lok Sabha, or the Chairman of the Raj Sabha. Additionally, under Article 105(2) of the Constitution, MPs enjoys complete protection in respect of anything said or any vote cast in Parliament, and no civil or criminal proceedings can be initiated against them for such acts. This landmark decision was delivered in the context of the famous cash for votes case, where certain MPs were alleged to have accepted bribes in exchange for voting in Parliament. Now let us study this case in detail. Answer: Petitioner Mr.P.V. Narsimha Rao versus Respondents, State CBI S.P.S and others. Citation: A.I.R. 1998 SC 2120. Subject: this case pertains to the privileges conferred upon the Parliament, its committees and members under Article 105 of the Constitution of India. Facts of the case: the case is famously known as the cash for votes or vote for note case. This incident occurred during the tenure of then Prime Minister Mr. P.V. Rao, who had to prove his majority in Lok Sabha following a challenge to his government's legitimacy. After proving the majority, allegations surfaced that certain members of the Parliament MPs had been bribed with crores of rupees in exchange for their votes in support of the government. When the Central Bureau of Investigation (CBI) initiated action against both the bribe givers and recipients, Mr. P.V. Rao and others filed a petition before the Supreme Court invoking constitutional protections. Supreme Court judgment: the central issue before the Supreme Court was whether members of Parliament fall under the definition of public servant as per Section 2C of the Prevention of Corruption Act 1988 and whether they enjoy immunity from criminal prosecution under Article 105 sub-article 2 and 105 sub-article 3 of the Constitution. A 5-judge constitutional bench heard the matter. Justice Mr. G.N. Ray delivered the majority opinion in a 3-judges to 2-judges judgment. The court held members of Parliament are indeed public servants within the meaning of Section 2C of the Prevention of Corruption Act 1988. Since there is no specific authority prescribed under Section 19(1) of the Act to grant sanction for prosecuting MPs, the court observed that criminal courts can take cognizance of offences under Section 7, 10, 11, 12 and 15 of the Act even without prior sanction. However, before filing a charge sheet, the prosecuting agency must obtain prior approval from the Speaker in the case of Lok Sabha member or the Chairman in the case of Raj Sabha member. Interpretation of the Article 105. The court elaborated that Article 105 of the Constitution provides the powers, privileges and immunities of Parliament, its committees and its members. A. Article 105 sub-article 1 guarantees freedom of speech in Parliament subject to constitutional provisions and parliamentary procedures. B. Article 105 sub-article 2 ensures that no MP shall be liable in any court for anything said or any vote cast in Parliament or its committees. The court emphasized that this freedom is an independent right and is not subject to restrictions under Article 19 sub-article 2. Article 105 sub-article 2 is derived from Article 105 sub-article 1 and both are complementary. Article 105 sub-article 3 addresses other privileges like immunity from arrest and the right to hold secret sessions. in term in respect of as used in Article 105 sub-article 2 was analyzed, and the court held that its interpretation depends on the context. An MP can claim immunity under this article only if a vote was actually cast or a speech was actually delivered in parliament. The court held that the scope of Article 105 extends beyond judicial proceeding to include all acts performed in connection with parliamentary duties such as speaking or voting in the House. Therefore, no civil or criminal action can be initiated against MPs for such acts. Conclusion: MPs who accepted bribes but actually voted in the House were held to be protected under Article 105 sub-article 2, and hence no legal action could be initiated against them. However, MPs who received bribe but did not participate in voting would not receive the same protection and could be prosecuted under applicable law. Accordingly, the petition was allowed. Principle of law laid down. In this case, Supreme Court established the following legal principles. First, MPs are public servants. Members of Parliament fall under the definition of public servant under Section 2C of the Prevention of Corruption Act 1988. 2. Peer approval required before initiating criminal proceedings against MPs. Peer sanction must be obtained from the Speaker in the case of Lok Sabha members and from the Chairman in the case of Rajya Sabha members. 3. Immunity under Article 105. No civil or criminal proceedings can be initiated in any court against an MP for anything said or any vote cast in Parliament, as they are protected under Article 105 of the Constitution. Please watch full video, share and subscribe to the channel. Thank you.